This is to the administrative offices of the Utah State Courts and the Utah Attorney General's office. Hoping you'll look into this. And I'm also going to turn this into the Federal Bureau of Investigations for further investigations. This is Justin Cunningham. So here is the preliminary hearing minutes for Clark McClellan, State of Utah versus Justin Cunningham, case number 111-80327. Same corrupt prosecutor, same clerk, same case. So count number, that. Court goes on for a little over an hour, and then I'll spare you the boring parts. I did put this on YouTube back then, 2011, so they all know about this complaint. I'll let you look at what they did document. Present court, proceed. Bevan Watkins testified. State exhibits. I'll save you all the boring details of what they did document. Cross-examination of witnesses. Defendant's counsel motions for dismiss for lack of evidence. Motion denied. Court finds probable cause. Communicate. Alleged crimes happen. Court will enter defendant's not guilty pleas. Matter scheduled for jury trial. With the tape count ends. Last tape count entry is 147. Goes from 139 to 147. Jury trial scheduled for 9/21. Mind you. And is it, if you can see that clear or not. 9 a.m. cutoff, August 26th. Set motion, plea cutoff, witness reports 1 week prior to trial. There's no more tape count. There's no more argument. Makes it look like it was clean, simple hearing. Nothing else. Also, no signature on this. There is nothing else said. It doesn't make clean, spiffy hearing. Nothing else said. Nothing else said. Here's the court minute entries on the docket. Same thing. Nothing else said. Defendant present with counsel. Same exact thing. Nothing else said. Defendant, nothing else said. Nothing else talked about in there. Lack of evidence. Alleged crimes committed. Jury trial scheduled. So, why wasn't any of this?
Substance by the Utah State Crime Lab and 30 days for notification of expert. Okay? So let's talk about.
Your Honor, I have someone like to say.
Talk to your attorney.
I tried to. He's not letting me participate in my doing things, and I have some objections. I'd like to request a hearing for a couple of reasons. I got the audio of the court minutes from my last hearing, and the transcripts are completely different. It's not even the transcripts of the same hearing.
We just had the preliminary hearings. That's the only issue that's before the court now is the trial. So it doesn't matter, Mr. Cunningham, it doesn't matter what happened at some other hearing. We are going to have a trial on these two cases.
Right.
So unless those two cases involve evidence in this case, why would I need to hear it?
It's the same case.
But what was the purpose of, what happened in that earlier proceedings?
I'll argue for Joe.
This may tangentially tie in, actually, Your Honor. He's very concerned about getting a speedy trial, which by being OR, he felt that he's been denied that right to speedy trial. So
How in the world being released from jail it affected your right to a speedy trial? When were you arrested?
When was I arrested?
Yeah.
I believe it was, early morning on the 1st of July.
Okay, now it is the 2nd day of August. We've had a preliminary hearing. That's pretty speedy. And we're going to set a trial date as fast as we can set a trial date. So what other records do you want to have me consider?
Right, it was this one. The audio, the court minutes, and the court minutes don't match at all. That's what.
But what does it
So
matter to you? What does it matter to what I'm doing here? I'm setting this matter for a speedy
I
trial.
have to obey the letter of the law. I think everybody in the court should too.
What is it that you're concerned about in the letter of the law, sir?
Well, you play the audio and read it, and it's not the same. And
Somebody needs to make a motion. I just don't sit down and say, okay, I'm going to listen
He's
to.
being ineffective counsel. I asked him to make a
Okay,
motion.
Mr. Cunningham, listen to me. Talk to your attorney. He'll make a motion if he believes it's appropriate. Just because you believe a motion needs to be made, it doesn't have to be made. I'll tell you that right now, okay?
And
He has an
I don't have
obligation.
the right. I don't have the right to request a hearing on it.
You have a right to talk to your attorney. If he believes that there's a legal basis for what you're asking for, he can make that motion. If he doesn't believe there's a legal basis, he has the right to make those decisions. Okay?
Okay. I just like to be on the record that I have several issues with this attorney. He's not doing what I'm asking him to do, and he's not making the efforts to. He just keeps telling me we'll talk after court, but after court ain't on the record. I want it on the record right now.
Well, I'm not going to put your conversations with your attorneys are never on the record.
No, but I wanted it on the court. I want it in the court right now because when we talk about Muhammad in court, it ain't any doing anything any good because he's not doing what we talk about.
Well, if you believe he has to do everything you tell him to do, that's an incorrect assumption, okay? He has an obligation to the court as well as to you, and his obligation to the court is to bring matters forward that are appropriate to be considered. If he doesn't believe what you're asking for is appropriate, he has an obligation not to do that. I don't know.
Can I ask a question?
Sure.
Question? At the point that I was arrested, did I have the right to a speedy trial?
You always have the right to a speedy trial.
And does your speedy trial right change when you're in custody and when you're out of custody?
There may be additional rights if you're in custody for the speedy trial, but since you're out of custody, you're subject to the rights of speedy trial for people that are not in custody.
But when you have a right to something, at what point does anybody have to take that right with me?
Well, if you're not in custody, you don't have the right. Listen to me. Don't interrupt me while I'm talking to you. If you're not in custody, your right to a speedy trial are those that are subject to people that are not in custody. So whatever those rights are, you have those. You don't have the same right to a speedy trial as if you were in custody. But either way, you're still going to get a speedy trial even if you were in custody. What you're going to have is speedy even if you were in custody. Okay?
Okay. Yeah.
So let's set this for trial.
Can I finish speaking?
Sure.
I was just curious at the point that I had the right to a speedy trial in custody, which is different, you just said. At what point did I lose that right to speedy trial? Because I didn't.
You haven't lost the right to speedy trial.
But the right is different, though. It's different from in custody.
You're going to have a speedy trial under the law. Doesn't matter whether you're in custody or not, you're going to get your rights.
I would just like formally request a hearing regarding some evidence that I think brings a whole different light on the situation. Because
Well, your right for a trial is on this issue. I don't know what hearing you want to have conducted, but we're going to have a trial, and that's what we're going to set. Okay?
Okay.
If you believe that there's some other hearing that needs to be brought, you bring it to your attorney. If he thinks it's appropriate, he can file a request with the court, and I'll consider it at that time.
Okay.
Okay.
Your Honor, may I make record of this time?
Sure.
Just to clarify things here, he is very upset that he was released from jail and that he was OR with no requirement to test or anything else. That's the basis of this. We have discussed the matter.
Okay. The fact that you were released OR with no requirement, most folks would look at that as saying that's the most liberty that a person can have, sir. So I'm curious of how that affects your ability to have your freedoms under the law if you're not in custody and you're not subject to testing.
Well, It just says right here, I looked on the website for the court, and I got this pre-trial non-bail releases and the requirements and the criteria, and I got my criminal history, and I got the criteria for the releases, and I don't fit any of the criteria. The only reason I can see that I was released on warrant is to deny me that right to speedy trial that I had while I was sitting in jail.
You're not in jail, sir. You are not in jail, so you're not entitled to the rights to a trial as if you were in jail. And the county attorney may well have chosen to do that, but that's within his prerogative.
At that point, I did have that right, and I just...
You are not in jail, you don't have that right, and it's not going to matter. You can argue till you're blue in the face, but if you're not in jail, you're not entitled to the same rights to a trial as if you're out of jail.
Exactly. Thank you very much.
And you're not in jail. So if you want to appeal that you want to be back in jail, I guess you can, but the court, there is no basis for that.
I just wanted on the record that my rights have changed, and I didn't know that anybody had the authority to change your rights when you had rights. I didn't know.
Absolutely. The county attorney, he could change your rights by dismissing this case if he chose to. That would affect your rights, and that would be significant, but he's not done that. So we need to set this for trial.
Affect or deny.
Let's set it for trial, sir. What's that? That's all right. Let's set case number 32327. You need middle of October is let's see. Middle of September is your earliest.
Correct.
I could do this September 29 or September 30th.
Yeah, I've got that. September 29th is a good day for me.
Okay, does that work? Okay, you.
So my question is, the law says the court minutes have to document everything that's said in court. Not word for word exactly, but everything that's substantial. So I had wanted to enter evidence on the record that at the bail hearing that they documented a false account of events. I had audio and the documents. I had asked my attorney to file a motion. He refused. I brought the documents with me. They refused to hear them. I asked for a hearing on the record. They refused. And this lady, Gillis, whether she was told to or whether she deleted it after the fact, but she didn't document anything that was said in court after they presented the evidence. And there's obviously a large gap in the minutes from her doing that. So she either didn't document it or she deleted it. But also, nobody signs these. Nobody signs any of it. Like I showed you in the other video, when the different clerks in there, the minutes are down to the, not just the minute, but they're down to the actual point of a second of the court hearing. And everything's signed. The judges sign it, or whoever signs everything signs off on it. And everything's documented, signed. But, and, you know, I invited the reporter to hear in the other hearing, in the next hearing. And, but yeah, they don't document everything. They document false accounts of events, delete everything that I say. I mean, that lady's job is to document everything that's said in there. And somebody's telling her not to document it or to delete it. And I'll show you at the bail hearing how they not only delete what's said, but they document a false account of events. So here's the conduct the judge blamed on me for wanting, saying that conduct was on me for previous conduct of the defendant, for him having to remove himself. Here's a newspaper article where I had accused him outright in court of perjury and collusion and false documentation of a court case. I don't know if you can read the article. Vernal man facing felony drug distribution charges in the East District Court was thwarted last week for his efforts to fire his court-appointed attorney, have the judge on his case recuse himself. Justin Cunningham, 34, accused of selling drugs to an undercover informant working for the Uinta Basin Narcotics Strike Force, April and May. During a tense court hearing Tuesday, Cunningham repeatedly asked the judge McClellan to review his request that McClellan not hear the case. Cunningham also wants a new lawyer to replace the defense attorney, Clint Hendricks. Cunningham claims the judge committed perjury and colluded with the county attorney's office. McClellan told Cunningham to he could not consider his request until he routed them through the proper channels. A frustrated Cunningham then sought to have his attorney file the motions, but was rebuffed when Hendricks refused to consult with him, and Cunningham then asked the judge if he could read the motion. "No, I cannot read it until you follow the rules," said Cunningham, adding that there was nothing he could see that would cause him to recuse himself from hearing the case. Although neither judge nor defense attorney could respond to Cunningham's request, they both offered to assist him in properly filing the motions. "I object to these proceedings and request to have effective counsel or to have my case dismissed," Cunningham said in response. He went on to claim that his right to speedy trial was violated and he was released from jail against his wishes. Cunningham was released from jail on his own recognizance on July 13 and believed the court his case is being deliberately delayed. For a long criminal history, and if you look at the Utah court website, I have no eligibility to be released on my own recognizance. The only reason I think they would release me is to deny me my right to speedy trial. McClellan told Cunningham, "You must refile your motions through your attorney before the judge could proceed further with his concerns about the case. The future court date for Cunningham has not been scheduled according to court records." That's not actually the only argument that was made. The fact that they're not documenting anything that's being said in court is what the main argument was. So here's their documentation of that same court hearing. There you go. Judge Clark McClellan. There's the court. There's the pretrial conference. There's the prosecutor, the very corrupt Mark Thomas. There's the very corrupt court clerk, Gillis. There's me, state of Utah. There's the case number, 111-800-327. There's the court date. I was talking about the court minute count. How the very other one was very correct. 10:56.45 or whatever. They don't even add a point in there. Defendant was present with his counsel. Defendant final pretrial hearing of the court that has not been properly served. The defendant's counsel on the stay. The court has not ruled on the pleadings until properly served. Has not been completed. Trial dates are vacated. Defendant have motions filed properly. State has to file their response 10/11/11. All motions are to be filed through the defendant's counsel. Clint Hendricks, defendant objects to ruling motion. End digits 11, 12, 28. So 10:56:45. So you're telling me all them words that reporter heard, all that stuff that the reporter heard is missing from that record. They just left it all out. The perjury, the collusion, all that stuff, they just didn't hear it. All these little bit of words, 15, 20 minutes worth of argument, It's condensed in there. Nothing I said is on the record. The collusion, the perjury, asking him to recuse himself. Nothing, none of the recusal stuff's in the record. The false document, none of that's going to be recorded into the record of my case. Now I have audio of that. What about the signatures? Remember and the judge is blaming the recusal for the misconduct on me. Where's the signatures at? Where's the signatures at? The huge gap in the court minutes. So all the stuff that this reporter heard, a tense court hearing, asking him to recuse himself, that none of that, they're just not going to record none of that on the record. So here's an initial appearance in the same case, same judge, July 5th, 2011. Justin Cunningham, same clerk. This initial appearance. Defendant appears in custody. Initial appearance. Defendant advised of charges. Question the defendant income. Mind you, I have a $10,000 cash only bail. Defendant indigent. Appoint counsel, Clint Hendricks. Preliminary hearings are already set for 8/3/11. Month away. State of Utah at the time, if you're in custody, you're supposed to have a preliminary hearing within 10 days. So they're already violating my rights by this case setting. Defendant can request a bail hearing through his attorney if needed. So if needed, I can request one. Again, there's no signatures on any of my court documents. There's the case number. Again, these videos were all posted on YouTube back when all this stuff happened. So, here is the documentation of this bail hearing on July 13th, 2011. There's the case number, same judge. Here's how this court clerk documented this bail hearing. The defendant appears before the court via Ike because I refused the bail hearing because it said I could request one if I needed one. I didn't need one because I had a cash only bail, and I already knew that they had violated my rights by setting out the preliminary hearing 30 days. When you're in custody in Utah under the speedy trial law, that's too long to set it out 30 days. In custody, they have 10 days to give you a prelim. By setting it out 30 days, they were already violating my rights. Counsel's present in the courtroom. I wasn't in the courtroom because I refused to go to a bail hearing. I didn't request one. It's not a mandatory appearance. Stipulation of OR release with no terms or condition is granted. Preliminary hearing is set for 8/3/11 at 9 a.m. Defendant has spoken with Mr. Hendricks about proceeding without counsel. Court will resolve the issue of counsel at the preliminary hearing. Mind you, that hearing was already set long before this hearing, at this other hearing. Remember, it's already set at this one. So why they got to set it again at this one? So, listen to the audio of this actual hearing. This is what they documented.
Okay, does that work? Okay, you are Justin Cunningham? All right, Mr. Cunningham, what's your birthday? 7477. Okay, they're telling me you're not feeling well, is that right? All right, I have your attorney here, Mr. Hendricks. He's with us. This is on for a bail here. Is there a stipulation?
Yes, there is, Your Honor. We stipulated that he be OR'd with the requirement that he test on red.
That is correct. Okay, the stipulation, sir, is that you be released on your own recognizance on the condition that you test on red. Do you understand what testing on red means?
I don't have the money before that, sir.
You don't know, you can't appear and test and pay for a test?
I don't have the money to pay for a test.
Well, I guess they can't do much better than an OR release. And a condition, the charges are drug related, and that will be a condition of the bail. So if you, or the release. So if you want out and you don't test, then you're just gonna get picked up again. So, okay, is this my case? I assume we're set for a preliminary hearing on August.
So you're telling me he set conditions that I have to test on red in that hearing. Right here it says no terms or conditions. Not once in that hearing did I tell my counsel I wanted to proceed without counsel. Nothing like that was said. And he said I had to test on red. So not only did they document a false account of events, that's a false account of this hearing, and a false statement saying I wanted to proceed without counsel. I did not say that. Proceed without counsel, right there. Did not say that, and that's a false ruling right there. Defendant feared before the court stipulated release with no terms or conditions is granted. That was not what was said. If that is not a false representation of that court hearing, I don't know what is. Especially when you have the tape count right there. That's the tape count. So if you want to say that those words and that false account of events happened on that tape count, as a matter of fact, where's the end of the tape count? There's the beginning of the tape count. I don't even see the end of the tape count. Now, I have that's the official court minutes. Here is there's the case number. And here's another thing that's odd about this case. All these dates. Anyways, defendant appeared before the court, Viac, because it was a video court. They forced me to go to a bail hearing when it said I could request one if needed. I didn't need one. I didn't request one. They forced me to go to one. Present in the courtroom, stipulated OR release with no terms or conditions is granted. That was not what was said. Preliminary hearing is set for August 3rd. Defendant has spoken with Mr. Hendricks about proceeding without counsel. No, I did not. Court will resolve the issue at counsel at preliminary hearing. So there's the audio tape count. Where's the intake count? Not seeing it. Why do they do that? Because they had to go back and delete it to type in this false account of events? Is that why? The law says that the minutes and the court documents have to be correct, true and correct. They can't just delete what happened and type in what they want to have happened. That's not how it works. If you can't have a fair and honest bail hearing, how can somebody be expected to trust the court to have a true and honest and fair trial? If the documents can't reflect what actually happened, then the justice system is broken. That's the bottom line. How can you ever appeal a case or a decision if it doesn't reflect what really happened? Have you ever seen a case where the minutes are modified in such a way so many times that it's being documented fraudulently in the first place, and then they got to modify it, and the audio recordings come up missing, that they got to reconstruct it from memory? It seems pretty fraudulent to me. They're the ones documenting it fraudulently in the first place. So this is actually in front of the same judge. This is a different case in 2022. This is what? The recusal of the same judge. Me going in front of the same judge. But he does recuse himself this time. And guess what? Different clerk, different prosecutor, different lawyer. Got a guy from out of town who I told him what happened last time. Now look at this minute clock with a different, not corrupt. These guys don't play by the same rules. That guy and this lady don't play by the same rules. So look at this minute clock. Yeah, I'm still a dirtbag. I still not proper, but look at this minute clock. Where's it at? Right here. Within 2 minutes, this hearing happened. Up down to the second. And guess what? This judge recused himself because he knew he had to. Because when I told this new lawyer what had happened in the past, this new lawyer said, well, that's a conflict of interest. That judge can't be your judge if that stuff happened in the past. And guess what? That judge knew better than to try it with a new lawyer from out of town. He wasn't going to have it. And guess what? This clerk wasn't going to have any of this nonsense. This clerk plays by the rules too. And see this document? These are actually signed and dated because that's how court papers are supposed to look. Signed and dated. Not like any of my other court papers. But the only thing is, the hearing of the record by the court recuses himself due to previous conduct of the defendant. So he's still blaming it. He's blaming all this stuff about this whole video, this whole thing that I've been talking about in this whole video. He blames it on me. All the stuff talking about the paperwork. My paperwork ain't signed. Nobody ever signs it. Huge gap in the court minutes. See these court minutes? How them are proper? Where's it at? Where's the other minute at? See how that minute? That happened in 2 minutes, this whole court hearing. The other ones had 20, 30-minute gaps. Open-ended. No signatures on none of my court paperwork. But still, the judge wants to blame the conduct of the previous conduct of the defendant on me. That nobody signs any of the other paperwork and left open-ended and wouldn't allow me to speak at my own court hearings and wouldn't document anything I was saying. Blame that all on me, huh, Mr. McClellan? Blame it all on me, huh? You had to recuse yourself this time because you are not honorable. These are Vernal City police reports and a sheriff police department report documenting the misconduct, false documents in this case, perjury in this case, all that. This case actually gets a lot deeper than that with some of the misconduct and criminal activity that took place against me. I made a much longer video that details step by step of what went wrong. It's over an hour and a half long. I'm going to send it to the FBI and post it on the YouTube if I don't get a response here. This video here just details the factual false documentation, doesn't detail some of the deep, darker manipulation that took place. I'm hoping to get a response from you. For 10 years, they denied me my paperwork at this courthouse until the judge retired and the prosecutor no longer works there. Gillis still works there. And now my court hearings the audios are destroyed, but the false documentation's still in there. So I'm hoping that you guys at the administrative offices of the courts will take this serious and look into it. Because I think it's pretty unfair that these guys were allowed to do this to my case. I can only imagine how many other people are sitting in prison that had their cases completely destroyed, falsely documented, weren't allowed to defend themselves in court, and, just a systematic conspiracy to deprive people of their rights in UN County in general. I mean, the police never looked into my factual complaints of false documentation either. That's a color of law violation. The equal protection of rights, equal protection of law violations also. So I'm hoping before I have to completely expose this, now that I know how to make videos, to the whole world. Thank you very much.